I'll let you know when it's up. Okay, I'm going to start the recording. Okay, you should be all good.
Hello, everyone. We are broadcasting live, and today we are bringing you a workshop on Know Your Rights for tenants, which covers eviction and maintenance. So we're going to wait a few minutes while people connect. Meanwhile, feel free to share. This workshop is useful in learning all about tenants' rights. So if you live in the state of Illinois, Will County, Cook County, these things will most likely apply to you if you are renting. So it's really important to know all these facts. And like I said, we'll wait a few more minutes while we wait for some more people to join us, and then we will get started. Can you see the blue screen now? So again, welcome. I see that there are a few people joining us, and this is a Know Your Rights workshop from Warehouse Workers for Justice, hoping to bring some facts about the landlord-tenant relationship and how that dynamic should ideally play out. What are your rights as a tenant and responsibilities from the landlord? And I hope this is useful. And if you have any questions during the presentation, feel free to drop your questions in the comments section. We'll have somebody reading them at the end. We'll address them. And we're always happy to provide you with the resources that you need, such as legal assistance for tenants' rights. If you know anybody who is facing an eviction, we're happy to help and guide them through that process. Or if someone needs rental assistance, that's something that we could also help with. So it looks like we have a few people already at 6:05, so we're going to get started. And this presentation is going to be recorded and uploaded up onto Warehouse Workers for Justice YouTube channel for later reference. So if you miss something, we'll be providing you with all the information. So thank you all for joining us. My name is Karen, and this is Know Your Rights on Eviction and Maintenance. So typically in the state of Illinois, a landlord has to start a court procedure in order to evict a tenant. And that is something that just doesn't happen overnight. It takes several months. And the first step to an eviction process in Illinois is for the landlord to serve the tenant with an eviction notice, whether it's posted to their door, sent to them via certified mail. The next step is the filing. Then you would receive a court summons, and after that you would attend your first day in court. After that you have your court hearing, and at the end of this very long process usually is when the judge will give an eviction order. So this process can take 3 to 8 months and even longer. We have seen cases that can take even over a year. And every case is different. That's why if you are facing an eviction, you want to speak to an attorney who is specialized in tenants' rights. And we have all those referrals available for you, whether you live in Will County or Cook County. And even if you live outside of those counties, we can still possibly find resources to help you. And it all depends on your zip code. So as long as you live in the state of Illinois, feel free to reach out for help. And so now let's talk about the types of notices that a landlord can serve you. The first type of notice that we have is a 5-day notice. And it usually is given to a tenant that has fallen behind on paying their rent. So the first 5 days is usually when a tenant should pay their rent. On the 6th day, if the landlord hasn't received the rent, or after that, they can serve you with a 5-day notice. And what this means is that you are behind on your rent. They will give you the total of rent that you're behind, whether that's 1 month or 2 months or 3 months. And this notice becomes null as soon as you pay that balance. So perhaps your payroll check came in late, there was some type of delay in the bank transaction. As soon as you pay that balance off, then this notice becomes null. And if for some reason you have been impacted by COVID and you have lost your job, there's rental assistance programs. We have a lot of referrals in Will County that we can help you in obtaining rental assistance. So that's a 5-day notice. The next type of notice is a 10-day notice, and this is usually given for a lease violation. So perhaps your lease says that there are no pets allowed, and let's just say you have a cat. Well, you have 10 days to figure out that situation, whether maybe you have your cat stay at your sister's for a while or you find another solution. The point is to negotiate with the landlord to give a solution to the violation that has been cited, and you have that 10-day period to negotiate. If you are able to work something out with the landlord, then this 10-day notice becomes null, and it shouldn't affect you beyond that. The 30 and 60-day notice are definitely something that you want to take a lot more seriously. And this is usually when we advise tenants to seek out for legal help, whether that is through an organization like Warehouse Workers for Justice or any other that are actively helping people with tenants' rights in your neighborhood. There's a lot of organizations. And this means that your landlord is intending to terminate your lease. So people who have a lease are more protected under the law versus people who are going on a month-to-month basis. So we always recommend for you to ask your landlord for a written lease, and we always advise you to read it thoroughly and that you understand everything that is on your lease, whether you'll be responsible for paying the utilities or what amenities in the building you have access to. All of these things should be stated in the lease. So like I had mentioned previously, your eviction must be in writing. It must be delivered in person. It could also be sent through certified mail, or it could be posted on your door. The eviction notice should not be given to you verbally through text message. It has to be through one of these methods for it to be legal and to count towards the process. And same thing goes with court summons. These type of notices have to be delivered by personal service from a sheriff or any type of special process server. So you will be notified that you have been served, and it can be given to anyone in your household who is 13 years of age or older. So that's really important to know. Right now, because of COVID, there have been special protections put in place, and eviction filings can be blocked if you fit into any of these categories. And you, as a tenant, have to make a sworn declaration, of course, under penalty of perjury, that you have fallen behind on your rent because of direct impact by COVID. So whether someone in your household has tested positive and you still have that paper as written proof, or you were cut hours from your work and there's a memo, something in writing that will prove direct hardship due to COVID, Another one of the requirements is that you will earn less than 99K per that fiscal year. And of course, that you will be greatly impacted and you could potentially become homeless if you were to be evicted. Um, and also something that is a really good sign of good faith that you are trying to catch up on your rental payment if you have fallen behind is the intent to make partial payments and that you're showing your best efforts into liquidating that balance, that you have done something, whether it's notify your landlord in writing. Like I said, keeping documentation is very, very important so that you can prove that you did notify your landlord when you perhaps lost your job or lost your income. And if you are applying for rental assistance, it's important to let your landlord know that there is a wait period, but you are in process, and it would be good to provide them with a letter saying, I have applied to this program, I'm waiting for a response, I will make payments as soon as I can, or here's $100, that shows that you are willing to pay and that this is in good faith. This is really important to know, and sometimes illegal lockouts happen, and that is why we're here, letting you know what your rights are as a tenant. So if you are renting or you have friends, you have family who rent, the landlords cannot change the locks. That is against the law. That is an illegal lockout. They cannot mess in any way with your locks, your doors, or your windows. They cannot shut off your your utilities or appliances. So if they control the heat or they control the water, that they cannot just shut it off. You can report this directly to 311, or if they have changed the locks on you, locking you out, you can call 911, and the police in Will County has proven to be very helpful in cases of illegal lockouts. The law requires landlords to keep your rental units fit to live in. So anything that would interfere with safe conditions that are not up to code with health or building regulations are things that must be addressed by your landlord. So if you have a broken window or drafty windows, or a ceiling the ceiling is leaking, an appliance is not working, these are all repairs that must be done by the landlord. And here's it's mentioned they have to stay up to date and comply with state and local health and housing codes. That's very important. So if your landlord is not addressing the issues that you have, feel free to reach out to us, and it's really important to request these things in writing, and there are several steps that you can take to ensure that your landlord is aware of the problems that are happening in your unit. And so that takes me to what a 14-day letter is. And in contrary to you being served with all types of notices, this is the notice that you can deliver to your landlord. And it's basically telling them, I am giving you 14 days to make these repairs. So whether that in this letter, you should list every single issue and detail it. And after that 14 period day, if the landlord hasn't addressed these issues, then you are able to legally reduce your rent for the next month. And now, this is something that you should seek advice and seek either help through an organization like WWJ or an attorney who is specialized in tenants' rights, because this process is very specific. You have to deliver the letter 14 days prior to the first of the month. So that usually falls on the 18th of the month. That's when you deliver a 14-day letter. And usually it is recommended to deliver it through certified mail, text message, or an email if you have your landlord's email. And there's also a set amount that you can reduce. So again, this is something that you would definitely need to seek help and advice from. And it's not something that I would suggest just doing it on your own if you are not aware of the rules that play into delivering a 14-day letter. And just a reminder, any of our resources, we do not charge. We are not an agency that offers services. We don't charge for any of this. So anytime you call, if we help you with a 14-day letter, there's absolutely no charge. We are a nonprofit organization and we're here to help the community and those who are facing eviction. So in more grave situations where, for instance, it's the middle of the winter and there's absolutely no heat and your landlord cannot fix it, you could also deliver them with a 24-hour letter. And what basically this letter does, it gives you a protection so that you can withhold rent and you can get a hotel where it's safe, and especially if it's a situation such as like the cold Chicago winter, where you have to seek safety and you're in a situation where you have to just leave the unit because it's not safe for you. You could deduct that cost from rent, or you could terminate the lease. And again, this is something that I would tell any tenant: seek help with an organization or a lawyer. I can't stress that point enough, because they will let you know how to do this process correctly. You have to be very careful when documenting these type of letters or issues in your apartment, so that if you end up in court, which hopefully not, but if you do, then you have all the evidence to back you up of why you reduced rent and the fact that you did it in a legal compliant way. Just like the landlord has to do an eviction process legally, us as tenants, we also have to follow certain rules. And because we're still suffering from these cold temperatures, here is a reminder of your rights in the winter as a tenant, right? And this is taking a little bit of information from the Chicago RLTO, otherwise known as the Residential Landlord and Tenant Ordinance. So this is applicable in the city of Chicago. Unfortunately, it does not apply to Will County, but nevertheless, in Will County, your landlord shouldn't shut off your heat. And roughly from September 15th all the way through June 1st, the temperatures in your apartment should never be below 66 to 68 degrees. And that's 68 during the day from 8 a.m. to around 10 p.m. and 66 during the nighttime. Sometimes landlords do control the heat. So just make sure if this is not happening and if your apartment is really cold or you have drafty windows that make this temperature drop, what I would tell you to do is buy one of those very like affordable thermometers. They're very small. You can get them at your local pharmacy. You can order them, like online, and basically take a picture of the thermostat in your unit, proving that it's below these appropriate temperatures. And if it's under that, record it every 8 hours so they can see that this is steady. And you definitely should call 311. You ask them to give you a reference number, and usually they'll have an inspector come out to you right away. Sometimes it could take a couple of days, but make sure you have that reference number so you could call back and be ready to receive a home inspector in your unit. You will have to give them access. And of course, notify your landlord. You want to do this in writing, whether that is through a text message or through a written letter, and keep record of all of your communication. And like it says here, document all your evidence. Take a picture of your thermometer with proof of date and time. So maybe someone else's cell phone that lives in your household, so you can prove that this was the temperature on Thursday, February 10th at 7 p.m. And lastly, I'm just here to remind you that Warehouse Workers for Justice is an organization that has access to many resources within Will County, within Cook County, and we try to help anyone who's just overall in the state of Illinois. We do have a hotline, and that phone number is listed here on the screen. Feel free to give us a call, leave a voicemail, leave a detailed voicemail, and somebody will get back to you within 24 to 48 hours. We have bilingual staff available. So if you're a Spanish speaker or you have friends or family that are Spanish speakers, let them know that we also speak Spanish. We also have someone who speaks Russian. So we'll figure it out. But if you have someone who doesn't speak English, still let them know that we can help. And of course, we have a tenant resource center, which is listed below, www.4j.org. And you can find a lot more information on our organization and all of the resources that we offer. We have help with expungements, driver's license reinstatement, workers' rights. Tonight is all about tenants' rights. And just as a reminder, in 2 weeks, which will be February 24th at 6 p.m., we're hosting our first Know Your Rights Tenants Workshop, and it's all going to be in Spanish. I'll be the presenter, so I will see you here again for more information, and I can't wait to read you all. So if you have any questions, please leave them in the comments. Thank you all for watching this workshop, and keep in touch through our social media, or you can give us a call in our hotline. So that is it from me, but we're going to answer a few more questions. Hannah will help me out with this section. So if you have any questions, please drop them below. Feel free to share. This will stay recorded. So if you want to share with friends or families on your page, feel free to do so.
While we wait for some questions to come in, can I ask you some questions that are pretty common that maybe some people might not know to ask?
Of course.
Cool. So are 5 and 10 day notices remediable? Can you get help from them?
Yes, these two types of notices are the least grave, least severe out of all our notices, right? And they do have a remedy. And of course, I would encourage anyone who has been served with a 5-day notice or a 10-day notice to reach out to us. You know, especially if you're not familiar with these type of notices, you don't know what it means. I know it could be really scary to receive one. I have received one. I used to rent in the city of Chicago, and of course, my landlord was not very nice and friendly. So it could be really intimidating to receive one of these notices. Like I said, the first one, the 5-day notice, as long as you pay your rent, that becomes null. It becomes null right away as soon as your landlord accepts your rent. And it's important to always pay your rent in check, not cash. And if it's cash, make sure you're getting a receipt, but always traceable documentation so that there's proof that you in fact paid your rent. And as soon as you pay that, that notice becomes null. And then the 10-day notice is usually given when there's a violation of the lease. So that could be really anything that maybe the landlord's not happy with. But of course, as long as you sit down and communicate, you talk to your landlord, if they are willing to be amicable, then that's something that you can resolve. And the 10-day notice gives you 10 days to resolve, right? So before that, the landlord cannot take any action. But you have that 10-day window to sort of work this out with them. And if you maybe are stuck in a situation where you don't know how to fix it, reach out to an organization like us, reach out to us. We're happy to help and walk through this process with you. It does not mean you're being evicted. 5 and 10-day notices are like a warning that something is wrong, but you are able to address it and fix it. The 30-day notice, that one is sort of like the more severe, like worrisome, where it's telling you that your landlord plans to start an eviction process within 30 days, but you still have those 30 days to sort of seek out a remedy and try to negotiate, try to talk to your landlord. And organizations like us, we can help you communicate with your landlord and let them know also what the rights and obligations are, so that both parties can reach a mutual agreement.
Awesome, thank you. Can my landlord notify me over text message that I have to move out?
No, while communicating with your landlord over text message is good
Mhm.
because it leaves documentation. The landlord cannot notify you via text message that they are going to start an eviction process against you. It Eviction is a very serious process that has to be taken to court. And the proper way to notify a tenant is through a 30-day notice. If you have a lease, then it's a 60-day notice. But nevertheless, they have to serve you, or they post it to your door, or it has to be in writing. And so, like I said, if you are facing eviction, or someone you know, a friend, a relative is facing eviction, or their landlord is threatening with eviction, I definitely say and recommend to seek out help from an organization with knowledge in tenants' rights, who can ultimately refer you to a legal organization that will not charge you if you are under a certain income bracket and you live in a certain zip code. So we must check eligibility first, but there's a lot of resources. There's a lot of help out there. And like I said, reach out to through our hotline or through our Facebook, any of our social media. We're very responsive and we're happy to help and direct you towards the right type of help.
Great. Seems like the chat is a little slow tonight, so I'm just gonna ask you two more questions and see if anyone trickles in before we're done with that. um, how about if there's no heat in my unit, what can I do? What are my first steps?
So the first step, like I said, would be you may call 311. Always ask for a ticket number or a reference number. And they usually are fast at responding at calls for no heat, but you will also have to document it. So, like I had mentioned earlier, you definitely need photos of a thermometer inside of the unit, and then with like maybe a phone, or if you have some type of device that gives the time and date, so you can show that that was the temperature at a certain date and time within the unit. You will be asked for documentation and proof. So 311 will ask you for that, and the home inspector will want to see that, because perhaps when the home inspector gets there, all of a sudden it'll be a little warmer. So you want to be able to prove that in fact it was below 66 or 68 degrees when and how long the problem has been ongoing for. So this is one of the issues that the city takes very seriously, especially in the winter. And they'll give you options like seek out shelter. And like we said, you can always go to a hotel, but you have to follow certain steps to be able to deduct that from your rent. And if that problem isn't fixed, you have the right to terminate your lease. And I know that's sometimes not ideal, but seek out help with an organization, give us a call, and we will be able to help you more. But do call 311.
All right, last question. I think this ties into what you were saying, but just maybe expand on it a little more. If my landlord refuses to make repairs, what can I do?
Yes. So documentation and always state what the issues are in writing. So the first step is um, definitely write them a letter saying, it doesn't have to be a very complex letter. It could just be, my name is tenant from certain unit, landlord's information, and saying here's a list of their issues in my unit, and try to detail them as thoroughly as you can, whether it is like the sink is not working, or the fridge isn't working, or an appliance, and list all of the problems in that single letter and deliver it to your landlord. You could do it through certified mail, but additionally, you could just send him a picture via text message in addition to the certified mail, so that you have traceable proof that he has been notified, so that if these problems go unaddressed, then that's when you can take other steps like delivering him that 14-day notice and ultimately deducting rent or paying for those repairs yourself, but billing him. So documentation is everything when it comes to tenant and landlord issues, because you want to prove that there are in fact issues. Nobody, nobody deserves to live in a unit where it's not in good, safe living conditions. You're paying your rent, and your landlord should definitely meet with his responsibilities. So those are the things that you can do and steps. And I can't stress this enough. If you have any issues as a tenant, feel free to call us. Even if you're not in Will County, we will direct you to organizations in your neighborhood that are able to assist you. And just use our hotline number or any of our social media.
Amazing. Doesn't look like we have any more comments or questions in the chat. So if you want to wrap this up, then I think we're good to go.
Okay, well, thank you for everybody who joined us. Feel free to share. If you are renting, this is very important information that we will be continuing to share with you. Like we said, we're having a Spanish workshop in 2 weeks again here on Facebook Live. And feel free to share. Let your friends know that we have all types of information around tenants' rights and tenants' issues. And don't be afraid. I have been served with some of these notices and everything was fine. You just have to be proactive about searching for help. And I'm going to leave this up here for you, any information. And if you see this after we are finished recording, you can still leave a comment and we'll get back to you. So thank you all. Have a great night. And if you have any questions, feel free to drop them in the comments section. Have a great night, everybody.